Greetings. My name is Z. Felicia Jordan, and I'm the Director of Social Security Representative Payee Program at Disability Rights Florida. I'll be presenting today Adulting 101, WIOA, Transition, and Finances for students with disabilities. So for your information, any contact, whether provided by Disability Rights Florida or its presenters, is presented for an educational, general reference, or informational purposes only. It is not intended to serve as legal or other advice. It is not intended to be a full and exhaustive explanation of the law in any area and should not be used to replace the advice of your own legal counsel. And Disability Rights Florida makes no representation or warranty for the content that is accurate, complete, or current for any specific particular purpose or application. In other words, I am an attorney, I'm just not your attorney. And because any legal advice or legal situation has to be individualized to the individual, there is no one size fits all. We prefer that you contact us if you need further information or assistance in regards to any services that we provide at Disability Rights Florida. So learning objectives. After this workshop, you'll be able to list what transition services are, who is required to provide them, and what they should help the student accomplish. To be able to identify priority issues to look for during the school to work transition for SSI and SSDI beneficiaries, to locate organizations and resources to help manage potentially complicated transition issues for students. So it's the 18th birthday. We have party hats and balloons and cake and adulthood. And what? So, no, really. A person is considered an adult legally upon reaching the age of majority. Once an individual turns 18 years old, regardless of disability, and that even includes cognitive impairments. So, legally, they're entitled to make all of their own decisions. So, what can we do? So we help that child prepare for adulthood, and this is also known as transition to adulthood. And we do that through education and training, employment, and community experiences. So we go from school to work. So by age 16, students are covered under IDEA, and they're required to have a further plan as they grow into their late teens. In Florida, we start the process at age 14 and we develop what they call a transition individualized education plan, the TIEP. And this is designed to be a result oriented process. So we're focusing on improving the academic and functional achievement, basically going with the student from school to post school activities. So this includes post secondary education, vocational education, integrated employment, including supported employment, continuing and adult education, adult services, independent living, or community participation. So, what does this transition process accomplish? So, it takes young people from disabilities from childhood to adulthood, and helps them move from being financially dependent to being independent, both socially and financially. So it includes a movement from IDEA services or 504 plans in an education setting to vocational rehabilitation services. Now, these may implicate Social Security benefits and healthcare benefits. So we always have to look at those things all together. So, what should each transition plan cover? Each transition plan should cover the youth's goals and supports and services that that young person with a disability will need to prepare for the fullest life possible as an adult. The transition plan looks ahead to the needs, the challenges, and the possibilities of adulthood. So, an IPE, which is different from an IEP, or employment plan, focuses on preparing for work as an adult. You're going to get that a lot between IEP and IPE. So look at those closely because those will switch around on you and it means two totally different things. If the educational system, the vocational rehabilitation agencies, and private and government social agencies can provide a service or support, and the person covered by the plan needs it, then that plan should show the way of how to get it. So if it's not in writing, it does not exist. So who should provide transition services? So schools and vocational rehabilitation services are both required to provide transition services to youth between age 16 and 22. And basically this is based on federal US Code 2020 section 414 D1 AI 8 or 29 USC section 723 A15. The services are provided pursuant to two documents. Again, you saw that I told you it was going to be a switcheroo, the IEP and the IPE. So the IEP is developed at the school, and the IPE, or the Individualized Plan of Employment, is developed with the Vocational Rehabilitation Agency. And these should work like bookends and work hand in hand in regards to basically reflecting the services that that young adult will need in the future. So how does the law define transition services? So transition services mean a coordinated set of activities for the student. So we're looking for an outcome oriented process. We're looking at how we get from starting gate to our goal. How do we get there? And we're looking at those, and it's going to have to provide movement from the school to post school activities. So post-secondary education, we're looking at college, we're looking at trade schools, we're looking at whatever education that will basically facilitate that individual. We're looking at vocational training. We're looking at integrated employment, including supported employment. We're looking at continuing adult education, adult services, independent living, and community participation. So we're looking at all those activities, and it's based on the individual student's needs. So it's not a one size fits all situation. We're taking into the account that the student's preferences and interests as well as their needs, and includes the instruction of and community experiences, the development of the employment, and other post-school living objectives. And when appropriate, we're looking at the acquisition of daily living skills and functional vocational evaluations. So these may include guidance and counseling, on the job training experiences, vocational training programs, and this is including college. So please don't exclude that if that's what your young adult can do, and it's their part of their strengths, and that's part of their desires. We're also looking at assistive technology devices and many other services. I included some transition services case law, basically based on what I was able to research, where the school was provided, the educational system was required to provide certain services for transition age students. This was as recently as May 25th, 2020, that I had looked at these cases to see if they were still viable. They have some where there are some distinctions against them in regards to other cases, but as we know, the law changes every day, so we have to take these with a grain of salt. But these are some of the case law that's available. Let's look at the Florida Vocational Rehabilitation Agencies. So Florida actually has more than one. So the main component of the Florida VR agencies, if we're looking at the Division of Vocational Rehabilitation, a person is eligible for vocational rehabilitation services if that person has a disability and requires vocational rehabilitation services to prepare for, enter, and engage in or retain gainful employment. And that's important because they don't just stop just because you got the job. So you also got to look at that retain gainful employment. In the Division of Blind Services, which is a different agency, they provide services to individuals who are blind, meaning that the individual has a central visual acuity of 2200 or less in the better eye with correcting glasses, or a disqualifying field defect in which the peripheral field has contracted to such an extent that the widest diameter or the visual field subtends an angular distance no greater than 20 degrees. So application, eligibility, and IP planning. So how do we obtain these services? This is the vocational rehabilitation process. So If you click on the link on the presentation, it will take you directly to the application. These applications must be signed by the applicant. So the DVR, if you click on it to Rehab Works, it'll take you to their application. And if you go for DBS and click on that link, it will have the application process for the Division of Blind Services. The application for services. So an individual may need, may select or have appointed by a court or a personal representative. So if you need someone to help you with it, you can basically request that, or if you want to help someone who needs it, they be able to do so. The application, in order to be effective, must be signed by designated to a counselor, and Disability Rights Florida can help with supervised referrals to ensure the assignment of a counselor in the initial meeting if required. So we're more than happy to help with that process. Eligibility determinations. Okay, the determination must be made within 60 days regarding eligibility. So this is by federal law that they have to determine whether or not you're eligible within 60 days. They can extend it, but it must be if it's an exceptional or unforeseen circumstances, and it must be agreed to by the client, in other words, you or your loved one with the disability, and include the time frame for eligibility. So if it takes longer than 60 days, they must have an agreement by you or your loved one who is seeking those services and includes a time frame for eligibility. The individuals must have a legal status and authorization to work in the United States. They must be present in the state. If not a resident of the state, a college student from other states, and we have a presumption of eligibility if you're receiving Social Security benefits. So eligible disabilities: mental health disorders, chemical dependencies, adjustment disorders, meaning short-term mental health disorders, intellectual disabilities, specific learning disabilities, hearing, speech, or vision impairments, and the specific documentation requirements for each disability is outlined in the Florida Administrative Code as listed at 6A-25.005. We do have the order selection in our state. DVR has instituted an order selection for individuals, and they have three categories: most disability, significant disability, and an individual disability. As we had checked recently, 1 and 2 are open, with the exceptions of people who had IPEs signed prior to February 19, 2014 to continue services uninterrupted. So they look at whether or not your eligibility and which category you're assigned to in regards to how quickly you start receiving services. Disability status is determined by an individual's limitations, functional capacities, the number of needed primary services, and the time those services need to be provided. So looking at either more or less of 6 months or 12 months. And if waitlisted while in school, you're going to contact the student's VR counselor prior to exiting school. So that means leaving under graduating or some sort of special diploma option to determine whether your category should change when he or she exits school. And under WIOA, the student may qualify for some services while still in school. So we look at the functional capacities regarding order selection. We're looking at mobility, communication, self-care, self-direction, interpersonal skills, work tolerance, and work skills. We also look at the individualized plan for employment. This is a written document capturing the individual's specific employment outcome, that job title. We're looking at the services or service providers needed to reach that employment outcome, the time frames for service initiation and provision, the responsibilities for the division and the individual, as well as any third parties who provide comparable services. So this should be all written out on your individualized plan of employment. So if all of these things are not written out, they need to be, and if not, you need to contact the Client Assistance Program, which is being housed under the Disability Rights Florida. Required coordination. The IEP for a student with a disability who's receiving special education services must be coordinated with the IEP for that individual in terms of goals, objectives, and services identified in the IEP. So as I said, these are kind of bookends. They're supposed to kind of mirror each other in regards to the needs and the goals and the desires of that individual or the student with a disability. Time frames. So the Division of Blind Services has a 60-day clock for IPE development from when they determine that you're eligible for services. And the Division of Vocational Rehabilitation Services has a 90-day window for IPE development. So that written document that we talked about, from the determination of eligibility, the Division of Blind Services has a 60-day clock, and the Division of Vocational Rehabilitation has a 90-day clock from eligibility or activation from a wait list to have that document developed. Ticket to Work program. So Social Security beneficiaries between the ages of 18 and 64 may receive employment-related services and supports under the Ticket to Work and Work Incentive Improvement Act of 1999. So Social Security beneficiaries are the recipients of Social Security Disability Insurance, which is SSDI, or you may hear it as DIB, or regular disability, or in the alternative, Supplemental Security Income, which is otherwise known as SSI. The Ticket to Work is not a physical document. It's a voucher for services that help eligible beneficiaries transition to work from an employment network, otherwise known as ENs, which includes both the Florida Vocational Rehabilitation Agencies as well as some private organizations and providers. So the Social Security Administration reimburses those employment networks participating in the Ticket to Work program when a client starts working at a sustained level. The ticket program may provide some protections from a continuing disability review while you're working and going to school. So while you're attempting to try to learn how to go to work, it provides some protection from a continuing disability review. Work Incentive Planning and Assistance Programs, otherwise known as WIPA. WIPA programs. These are work incentives that enable Social Security beneficiaries to transition from benefits to sustain earnings through employment and to continue to receive medical benefits while working. These programs use community work incentive coordinators who counsel Social Security beneficiaries on their benefits and possible impacts while working. There are 4-week WIPA programs in Florida. There's a Service Source Abilities in Clearwater. There's a Brevard Achievement Center in Rockledge outside of Cocoa. There's a Center for Independent Living in Central Florida in Orlando. And there's Independent Living Resources of Northeast Florida and Opportunity Development in Jacksonville. So one of the other things you can do is, while you're going to get vocational rehabilitation services or services from the Division of Blind Services, you can also request that service as part of your IPE planning, so that way you can be able to coordinate it. SSDI work incentives, trial work periods. Trial work periods allow the beneficiaries to try working without losing their benefits. The period lasts 9 months. These are not 9 months like consecutive, meaning 1, 2, 3, 4, or January through September. This is a rolling 60-month period. So you're looking at 5 years. So a month counts towards a period when a beneficiary earns more than the monthly threshold for that year. And in 2020, the monthly threshold is $910. SSDI work incentives, extended period of eligibility. After the trial period is exhausted, so after you get your 9 months of trial work, there's a 36-month period where the beneficiary still may be able to obtain benefits if they do not earn more than the substantial gainful activity amount. So for 2020, this is $1,260 for persons with disabilities, and is $2,110 for individuals who are blind. And reapplication is not required for this benefit. Impairment-related work expenses. So these expenses are paid for by the beneficiary for their work, but can be deducted from earned income. So impairment-related work expenses may include service animals, medicine, medical supplies and devices, personal assistance, transportation, and modifications to vehicles, none of which may be reimbursed by the employer or others. So when you're looking at the trial work period and how much you earned, you also could look at the impairment related work expenses to see how that is deducted from the earned income and seeing whether an individual is still eligible for Social Security benefits. SSDI work incentives, a subsidy. Social Security determines the actual value of a person's work. Is any excess amount paid by the employer is in a subsidy. So for example, if a job coach may provide assistance which shifts some of the beneficiary's work onto the job coach, the value of the work that is done by the job coach, no matter who is paying for the job coach, is subtracted from the earned income when determining the beneficiary's substantial gainful activity. Continuation of Medicare. So at the end of the trial work period, if the beneficiary who is still disabled loses benefits due to exceeding substantial gainful activity, Medicare A, which is hospital, home health, and nursing, may continue for a minimum of 93 consecutive months, which is 7 years, 9 months. Medicare for people with disabilities who work, the individuals with disabilities who are not yet 65 may buy into Medicare Part A. And once Part A is purchased, Medicare Parts B and D can also be available for purchase. Okay, so SSI work incentives. We have earned income exclusion. So remember, this is for students. They take $65 off for the earned income exclusion. And then if the student is earned income exclusion for 2020, that's $1,900 a month, no more than $7,670 a year. These are available to persons under 22 who are regularly attending school. So this is not for everyone. This is for students who are regularly attending school and are basically have an earned income exclusion. SSI work incentive for expenses. Again, we have our impairment related work expenses. So expenses paid by the beneficiary related to their employment and their disabling conditions are deducted from the earned income, and it cannot be reimbursed by the employer or by others. And blind work expenses, these are related to the employment but not necessarily blindness. So these are broader expenses that may be applied to include the earned income that pays income taxes and meals while working. So we also have to look at that as well. Okay, pop quiz number 1. So Arnold is receiving SSA disability benefits or DIB regular benefits. And he's working at the Tri-County Sheltered Workshop and is receiving an average of $425 a month. Is he still eligible for benefits? Yes, he is, because he's working at a sheltered workshop and they could look at the subsidies of his job coach and the type of work he's doing in regard to determining whether or not he meets SGA. So let's go back to Arnold in our pop quiz number 2. Arnold's working at the same local Motel 6, earning the same income. Will he still be eligible for benefits? Yes, he would. Arnold's basically earning less than SGA. Now, for SSI, he may have some deduction on his benefits depending on whether or not his impairment related work expenses or other things that may contribute. Plans to achieve self-employment. SSI recipients or other possible recipients can set aside other income in the pursuit of a work goal that will reduce or eliminate the beneficiary's Social Security benefits. These are past plans. These are plans to achieve self-employment. Individuals who are receiving SSI may become SSDI, may become SSI eligible if they set aside their SSDI funds in a past plan. So these are individuals who are trying to have their own self-supported business. And the PASS cadre is in Birmingham, Alabama, and they have coordinators that will help you set up these plans. You can't just go out and do it on your own. You have to go through the process and make sure that it's acknowledged and written down. Expedited reinstatements. These are incentives that are available after the benefits are lost due to reaching substantial gainful activities. If it's within 5 years of the loss of benefits, they can be reinstated if the beneficiary can no longer work without need of a new application. Temporary benefits may be provided up to 6 months while an eligibility determination is being made, and this is applicable both to beneficiaries of SSDI and SSI. So, in other words, if within 5 years of losing your benefits due to making substantial gainful activity, you can basically be reinstated without a new application. And they may be able to provide temporary benefits while they're doing a determination for eligibility. Workforce Innovation and Opportunity Act, otherwise known as WIOA. So the Workforce Innovation and Opportunity Act, the WIOA, was signed into law on July 22, 2014. This act reauthorized the Adult Education and Family Literacy Act with several revisions and became effective on July 1st, 2015. So I also left regulations here, 34 CFR Part 361, which is the Vocational Rehabilitation Program regulations, as well as 34 CFR Part 370, which is the Client Assistance Program regulations. So we have pre-employment transition services. So it increases service to youth and it emphasizes the need for youth with disabilities to have more opportunities to practice and improve workplace skills, to consider the work career interests and get real work experiences. It expands the education and training options to help participants access good jobs and advance careers. It helps disadvantaged individuals and unemployed youth earn while they learn, and it aligns the accountability across core programs. So we look at job exploration counseling. We're going to look at work-based learning experiences, including in-school, after-school opportunities, and experience outside of traditional school settings, including internships, that provides an integrated employment to the maximum amount possible. So we're trying to get our students out in the community to be able to try to have them work in these different opportunities as much as possible. Counseling on opportunities for enrollment for comprehensive transition or post-secondary education programs at institutions for higher learning. Workplace readiness training to develop social skills and independent living. And instruction in self-advocacy, which may include peer mentoring. So these all could be provided by the Division of Blind Services or the Division of Vocational Rehabilitation. So who is the pre-employment youth? So youth with a disability is an individual between 14 to 24 years old and they're eligible for vocational rehabilitation services. There's no potential eligible. So it's a larger group of students with disabilities. With the Workforce Innovation Improvement Act, 15% of each state's public VR funds now must be used for pre-employment transition services. So this includes in addition to transition services which have been retained. So for students, the employment outcome may be the post-school outcome that we're looking for in the future. WIOA and DVR/DBS role in transition. DVR and DBS should participate throughout the transition planning process, not just when a student is nearing graduation. The earlier we can begin, the better. DVR/DBS is expected to provide services to at least some students with disabilities while they're still in school. And when the transition is provided by DVR/DBS, that they're providing those services as if any other VR service, they must be designed to, quote, promote or facilitate the achievement of the employment outcome identified in the student's IPE, unquote. Congressional intent for WIOA. So the intent for this was to increase the focus on servicing the most vulnerable workers. These are low-income adults and youth who have limited skills. So we're focusing on increasing the job skills, the career pathways, and in-demand occupation. And we're focusing more on employment engagement. So we require public DVRs and DBS and workforce development systems to become better partners. So we're trying to get our young adults to be able to have more access and more opportunities to be able to work in the competitive field as much as possible to the extent that they can do it. Workforce Innovation and Opportunity Act. So we're looking at the services to individuals. We're looking at inclusion of customized employment. And we're encouraging individuals to pursue careers in advanced training in science, technology, engineering, mathematics, including computer science, medicine, law, or business, and extended services to youth receiving supported services, employment services. So a lot of people don't know that under this particular act is not only going to be a bachelor's degree level or associate's degree level or vocational certificate. We can also look to vocational rehabilitation or the division of blind services to help provide services for further education, like more on the master's degree level, because of they're trying to get people to pursue careers in advanced training in these areas. WIOA and sheltered workshops. So we're doing the limitations on use of minimum wage. So before working at a rate below minimum wage, the youth with a disability must receive pre-employment transition services first, refer to VR for services, and receive career counseling. So this is before you go into a sheltered workshop. They're supposed to look at those in the situation first and see what you can and cannot do. VR must review those individuals employed in non-integrated settings semi-annually and report the information about individuals in extended employment to the Wage and Hour Division at the Department of Labor. SSI redeterminations. So, the schedule. At age 18, a review is scheduled to determine whether or not a condition or illness meets the Social Security Administration definition of disabilities for an adult. So the individual will switch from the child definition of being disabled over to the adult definition of being disabled. The adult standard includes an inability to perform any jobs that exist in substantial numbers in the national or local economy. To be found disabled under the adult standard, the young adult must at least show that they are unable to meet the basic standards or demands of at least sedentary work on a sustained basis, or unable to meet the basic mental demands of simple unskilled work. The evidence. When the case is reviewed, evidence from all medical, vocational, and educational services should be obtained. The medical evidence can come from medical practitioners, including doctors, nurse practitioners, physician assistants, naturopaths, chiropractors, therapists, physical, speech, and occupational, and psychiatric social workers. Recent records. Not having recent records of medical treatment, vocational services, or education services may result in a finding that an illness or condition is no longer disabling for the SSI recipient. Under transitioning youth for SSI determination, the transitioning youth should continue to see their doctors and other medical professionals, participate in the appropriate educational or vocational training, especially if there's no recommended treatment for the disabling condition, and provide Social Security Administration with access to all medical, vocational, and educational reports. So under SSR 09-2P, redetermining childhood disability, the documenting a childhood's child impairment related limitations, this regulation gives an extensive discussion of documenting a child's disability through IEPs. These IEPs can be used to document a disability of a young adult who is 18 to 22 years old who is still in special education. So this is important, that if you have a young adult within that age group and they still getting their IEPs and they're attending school for FAPE, please retain them. Please hold on to them. You may need them. Under the SSR 11-2, documenting and evaluating disabilities under young adults, this regulation consists of individuals from 18 to 25 years old to be young adults. Therefore, SSA will use the same criteria for determining disability for older adults. However, they'll take into consideration any documentation or information available from non-medical service sources such as social workers, therapists, vocational coaches, and family members. So that's important to try to document those information as much as possible, especially when you're going to IEP meetings or seeking treatment. Warning for SSI determinations. The loss of SSI benefits through a finding that the youth is no longer disabled may result in the loss of Medicaid, as well as the loss of Medicaid waiver services, including developmentally disabled waivers. Also, warning, living arrangements and food provided by the family may be determined as in-kind income that can affect SSI eligibility. The same applies to income from a parent or spouse who may be deemed to the youth. So, in other words, if you lose SSI benefits, you may lose your Medicaid benefits, including waiver support benefits. And the living arrangements, they basically are going to look at that as in-kind income. If that individual is not paying their fair market fair share of the housing and the living arrangements and food, they're going to count that as in-kind income and deem it down to the individual, which may reduce their SSI benefits. Pop quiz number 3. So David is a 19-year-old student who still attends high school. He has an intellectual disability with a full-scale IQ of 65. What documentation can you use to determine he's still eligible for SSI benefits? So there's a lot of them. We can look at medical records. We can look at therapy records. We can look at IEPs. We can look at IPEs and employment vocational evaluations. We can look at information from family members who may have documented some of the situations that David has. So a lot of those things, if it's written down and documented, Social Security can look at to determine whether or not David is still eligible for SSA benefits. Continued payment under a VR or similar program, Section 301. So if a finding is made that a person is no longer considered disabled, Section 301 allows a SSI beneficiary to continue to receive SSI benefits, including benefits like Medicaid. SSI benefits may be protected when a youth participates in an appropriate vocational rehabilitation program or similar services. So something that you may look at if that individual is no longer considered disabled. The appropriate vocational rehabilitation programs or similar services include Ticket to Work, like we discussed earlier, an IPE through a vocational rehabilitation agency, a plan to achieve self-support like a PASS program, or an IEP for an individual between ages of 18 and 21. So to be eligible for Section 301 protection, an individual must be already participating in a vocational rehabilitation program or similar service at the time of disability cessation. Protected Medicaid. So if SSI cash benefits are lost because the childhood disability benefit exceeds the income allowance for SSI, then the ancillary benefit of Medicaid eligibility can be preserved. So under that is formally known, then we're looking at childhood disability benefit eligibility. So basically what this is if an individual who's formerly receiving SSI benefits starts receiving Social Security benefits or regular disabled benefits under the childhood disability benefit, It was formerly known as the Disabled Adult Child, which is known as DAC. This is somebody who's 18 years old, age or older, and disabled before age 22. Their parents became disabled, retired, or deceased, and they are insured workers under Social Security. They file the application for the child's benefits, and the individual has to be unmarried. So if that adult child gets married, the benefits end unless the marriage is to another Social Security beneficiary. So I've had cases where that happened. You have to look at that and be careful. Eligibility, you have to be over 18, have blindness or a disability that which began before age 22. That's the magic number, before age 22. They're entitled to Title II benefits or SSDI benefits based on the parent's records due to the disability. The parent's disability, the parent's retirement, or the death of the parent, and will lose SSI either because they're receiving regular disability or an increase in that benefit. The SSI eligibility would continue in the absence of the Title II child disability benefit, meaning that the disability itself is still continuing. It's the type of benefit that is changing. 1619B, Medicaid while working. 1619B is an individual who earns enough income to become ineligible for SSI can still maintain Medicaid benefits. The receipt of 1619B Medicaid protects the individual for reinstatement of SSI benefits should that accountable income decline. And it also can protect eligibility under the state's Medicaid waiver programs while working. To be eligible, the individual must have a disability, meets all the SSI eligibility requirements except for the countable earned income, have received SSI for a previous month in the eligibility period, need Medicaid, not have earnings that would replace the SSI benefit, the Medicaid benefit, or any other personal care services paid for by public funds. Post-secondary education services and support, and we're looking at extended foster care programs. Extended foster care program started on January 1st, 2014, and the youth has a choice to stay in foster care until age 21. The program gives kids living options and a support network in order to assist them to transition to adulthood. Young adults with a diagnosed or documented disability may continue to reside in extended foster care up until their 22nd birthday. At the age of 18, residing in licensed foster care and attending high school or working on a GED, or enrolled in college or vocational education program, or employed for at least 80 hours per month, or participating in a program designed to promote or eliminate barriers to employment, or have a diagnosed and documented disability that will prevent the young adult from participating in any of the activities listed above. So this is our transition checklist, a little homework for you. 1. Start planning early. A well-managed transition provides for the chance for the greatest possible independence, employment opportunity, and fulfillment, preferably starting at age 14. Apply to the Division of Vocational Rehabilitation or the Division of Blind Services as appropriate, starting at age 14. 3. Invite a representative from the appropriate vocational rehabilitation agency, either vocational rehabilitation or blind services, to the IEP meetings. Ensure the coordination of the IEP and the IPE through both the school and the vocational rehabilitation agency. So have a representative at those meetings. 4. Apply for available services and scholarships, i.e. waiver programs, VR services, RTIs, and etc. 5. Keep a watchful eye and seek assistance with income and benefit issues. Contact the WIPA programs or Disability Rights Florida with questions about interplay of work, income, and benefits. Seek assistance in case of an overpayment of Social Security benefits, especially if it's a barrier to employment. 6. Continue to see doctors to understand disabling conditions. 7. Determine if that individual youth can handle their own Social Security and health benefits and who will assist them if they need help. 8. Identify accommodations of the youth will need in employment or in a post-secondary education program. So prior to leaving high school, if a person has to have certain accommodation, your young adult, make sure it's documented so that if they go into a post-secondary situation such as college, that those can be followed as much as possible in that new environment. 9. Remember that earning wages causes SSI benefits to decrease, but increases overall income. And work puts a person with a disability on a path to being an insured worker. How we can assist. We advocate for the rights and the needs for people with disabilities with both state vocational rehabilitation services, the Division of Blind Services and the Division of Vocational Rehabilitation. And we address other employment related issues such as employment discrimination, reasonable accommodation, work related transportation, Centers for Independent Living, Social Security Work Incentives and WIPAs, employment networks, and other barriers to employment. We also have our 2021 Public Input Planning Survey, and your input matters to us. This is how we find out what we need to do for our state in the following year. So please visit the link below between June 1st, 2020 and August 15th, 2020 to complete our annual Public Input Planning Survey. Your responses will help us plan our goals, priorities, and objectives for 2021, and there may be a prize for you at the end. Again, I am Z. Felicia Jordan. I am the Director of Social Security Representative Payee Program, and I can be reached at the information related below. These are some of the resources that I attach in regards to helping you find more information for the transition of your young adult or for yourself if you happen to be a young adult.